mere feet away, live and in person, about what Mr. Chauvin is doing to Mr. Floyd. So that foundation we will be able to lay through his testimony, all of which has been disclosed, and will be offered for those opinions. So we would ask the court to deny this motion.
I think at some point it becomes a medical opinion, and I don't think the state is offering it for that purpose. For example, that it was the hold itself which contributed to the death of Mr. Floyd. It appears to me that this is actually similar to the firefighter, where this person can talk about their training and experience. And specifically, I think in this case, because he does say, and it is audible on the video, that the terms blood choke, I think he is entitled to say what his experience is and to explain what he meant by that. And also the shimmy, to be honest, that's what he thought he saw, and that he thought it had gone too far, because in his training, once a person is unconscious, I assume this is what you're talking about, Mr. Frank, that once he's unconscious, that the hold should be lifted. That's his training. He's not to opine on anything else. He can't say this is what causes death, or this is what caused him to go unconscious. All he can do is talk about his observations, and based on his experience, that he thought it was a blood chokehold, that he wasn't seeing a shimmy, to explain what those terms mean according to his experience. And I would even allow him to say, and based on his experience, he thought that the hold was kept on too long. I think beyond that, then we start talking about medical opinions. Did it cause the death? Did it cause him to be unconscious? I think he can talk a lot about his observations and explaining what he thought about the hold itself and how that it went too long. Is that kind of clarified for the state where I'm drawing that line?
It does, Your Honor.
Mr. Nelson?
It does.
All right, let's move on to the next.
Thank you, Your Honor. The next motion is number 23. I think this is, again, very similar to the motion yesterday involving Genevieve Hansen. Again, we're not contesting that firefighters who responded to the scene can testify as to their observations, as to the course of medical treatment that they attempted to use in the resuscitation efforts for Mr. Floyd. Ultimately, it's just their opinion as to what the cause and manner of death were. I mean, that's what I'm seeking to exclude.
All right, is the state attempting to do so? Mr. Blackwell.
Good morning again, Your Honor.
Good morning.
No, we're not. And it's mostly just to be clear about sort of what we mean. We talk about, cause and manner of death, or not testifying about any contributing factors. What does that mean? The paramedics are obviously there on the scene doing everything they can to revive George Floyd's life, who had been without a pulse for several minutes. And the jury is entitled to know what they saw, how they reacted to it, what treatment modalities they decided to employ, which ones they decided not to. And then when they get to Hennepin County, to the emergency room, where they will be further attempting to revive Mr. Floyd, what they reported based on their observations and experience. So that's all actual. And that is what we would intend to impart to the jury, Your Honor.
How is this different than the rulings I made on the off-duty firefighter?
I don't think it is.
Whether a person's off-duty or on-duty, when they have virtually the same qualifications, I would allow the same type of evidence. Accordingly, what the firefighters saw when they arrived, the symptoms they saw, whether the person was in medical distress, what techniques they thought were appropriate to intervene. All the things that I said for the off-duty firefighter, I think apply equally to the other one. It's just observations of what they saw, what attempts were made of revival or resuscitation. I think it's the same line is drawn as for the off-duty firefighter. Okay,
Very well, Your Honor.
thank you. Mr. Nelson.
Your Honor, I think we could probably quickly dispatch of number 25 and 31 as well. 25 being exclusion of any reference to Mr. Chauvin's invocation of his Fifth Amendment rights. I had a brief chat with Mr. Frank, just for point of clarification. We are not seeking to suppress any statements that were made or that were captured on body camera footage. We agree that that's admissible, and in fact, we've repeatedly stipulated or offered to stipulate to the admissibility of the body-worn cameras from the incident. Likewise, other officers capture conversations and their body cameras. For example, a sergeant responds, asks what happened. Custodial, it's non-testimonial. We're stipulating that that all comes in. Ultimately, when this turns to a critical incident, however, Mr. Chauvin is brought to room 100 of the City Hall, which is the standard practice in critical incidents here in Minneapolis, and is afforded an opportunity to consult with a lawyer at that time. The lawyer who responded, they didn't make a statement. And I believe ultimately we are in agreement that there would be no reference to the invocation of the Fifth Amendment rights at that point beyond. Anything that happened before that's captured on body camera, we agree is admissible.
Mr. Frank, sounds like we're in agreement.
Yeah, with our understanding that that is the sole basis of this motion, we would agree that the council decision to not give a statement is off limits.
So you're saying that you could somehow elicit pre-custody that he did not give a statement?
Well, there are pre-custody statements and lack of statements that would not be covered by the Fifth Amendment, correct?
I think it's always complicated with a peace officer in this situation with the Castigar and Garrity and the statutory protections. So it's not like a civilian on pre-arrest silence. There's all these other statutes that protect them. And has everybody thought about that?
Well, I would say not fully, Your Honor, because I'm not sure of the extent that those cases would apply to the very situations that Mr. Nelson was talking about.
So ultimately, Your Honor, the prior to him being brought down to room 100, before this was deemed a critical incident, everything is captured, literally everything is captured on one body camera or another. I don't believe that those constitute Garrity statements. They're not forced statements. They're not being, he's talking with Officer King or he's talking with Officer Tao at the scene. No authority figure from the police department is compelling him to make those statements. I don't think Garrity applies in that context. Again, I agree all of that is within bounds, anything that is or isn't said. But in terms of saying, once he gets to room 100 and a lawyer is afforded to him and a lawyer counsels him, that's the basis of the motion. I think it would be improper, for example, if the state says, well, Mr. Chauvin didn't make a statement to his sergeant in that instance. I think that would be improper. And also, in this situation, statements were made. He was standing there right next to the other officers who were involved when they gave the public safety kind of statement about what happened. And so again, I think that's all admissible. I would agree that that's all admissible, but an inference that his silence in that circumstance would not be proper. I mean,
Right.
All right, an adoption of a statement by silence would still be admissible, is not prohibited by this. So what we understand counsel to be saying is he is not raising any issue with respect to anything said up to the council decision at City Hall. But we do not agree that if there were adopted statements or, silence, statements by silence prior to that point, that they would be covered by the Fifth Amendment either. And the case law that the court is talking about, well, I guess I'll just leave it at that because that's our understanding of the motion.
I think I was referring to when critical incident is a term of art that we all use. And I think when you start declaring a critical incident, it kicks in potential garrity and castigar issues. But it sounds like you're not intending to offer any evidence of silence, pre-arrest silence between it's a critical incident to arrest. Where are you?
We might.
All right, we're gonna have to probably have a conference off the record when we get to that point in trial.
Okay.
So I'm gonna reserve ruling. I think everything up to all the body cams, et cetera, up to the time of a critical incident, you would agree, Mr. Nelson, that all is appropriate.
I agree.
Okay, and state agrees with that. It's that question of critical incident declaration to arrest. It's pre-arrest silence, but does the fact that it was declared a critical incident. So let's talk a little bit more about that when we get to that point in trial. But those are the limits for now. And if you have any other authority that you can throw my way, and I may be sending you down a rabbit hole, I recognize that, but I would like to make sure we cover all the unique aspects of this situation.
Okay.
Mr. Nelson.
Thanks. And I think we can also quickly deal with number 31, which is a motion to exclude the statements of officers Tao and Lane. And for points of clarification, officers Tao and Lane gave tape recorded voluntary statements to the BCA and in connection with the FBI, counseled by attorney. They signed criminal investigation warrants, understanding that their statements can't be used or could be used against them. That's all I'm talking about. I'm not, again, talking about what's on the body camera footage or those statements. I believe, based on the submissions the state has already agreed to, that they agree that that's testimonial evidence, that I would not have the ability to cross-examine those other witnesses. I confirmed with each of the attorneys last night that they are not permitting their clients to testify in this trial. I would have no ability to cross-examine those particular statements. Anything else, again, I think it's fair game.
Is the state intending on offering any of that, Mr. Frank?
We would not offer them, but there is the issue of expert reliance. I suspect both sides' experts have relied on those. So I just want to make that clear.
Well, I think they could say that they have reviewed the statements of those officers, but that, I mean, and I know things could be admissible to show the basis of the officer's opinion or the expert's opinion. But I think I'm not going to let you do it unless you get permission from the court at the time and show a good need to actually get the substance to form the basis of the expert, because the expert's testimony is not supposed to be used as a backdoor to get in otherwise inadmissible hearsay.
That's understood, George. That's fine.
Okay. So just be clear, I will allow your experts to say they did review those statements. That's it at this point.
And then we have number 26, which is a motion to exclude any testimony or reference to a blue line of silence or some sort of conspiracy of police officers to remain silent and not cooperate with investigations of other police officers. I believe in this case, there would be absolutely no evidence of that. Every single police officer made statements. They all cooperated. They all went into the BCA or the FBI. They made statements. They were represented by attorneys again. So there is no lack of cooperation by the Minneapolis Police Department in this case. And I think that any reference to that would simply be to try to inflame the passions of the jury or create some sort of a conspiracy that the officers are just trying to cover themselves or protect one of their own.
State's response?
You want me to remain here?
I think as long as we're picking up your voice on the microphone, you can stay there. Maybe pull the microphone a little closer.
Your Honor, I would say that, well, by and large, the Minneapolis Police Department and its personnel have been professional and cooperative. I think it could be argued, we cannot say entirely, but by and large, for the most part. We do not intend, for instance, an opening statement to make statements about a blue line or something as represented in this motion. However, we cannot be, it's our position, prohibited at this point from raising, bias if that becomes apparent during testimony at trial. And that is possible. And so I think this motion is in that sense then premature because, it should be determined on a witness by witness basis. If bias comes up that looks like this during trial, we should be allowed to explore it for that particular witness.
Perhaps, but these are loaded rhetorical devices that have been criticized by many parts. It is inflammatory to talk about a wall of silence, a blue line. In fact, I think the original thin blue line phrase came from a defense attorney talking to a client being part of the thin blue line that protects us against or protects civilization against anarchy. So it actually, I think its origins are not in prosecution. And the problem is it's a rhetorical device that is inflammatory and goes towards culture. And I'm unlikely to allow you to do it in any case, but if you think it arises as necessary and as evidence of bias, let's do a sidebar and decide that. Right now, I cannot conceive of when this type of rhetorical device is appropriate. So we'll go with that.
Thank you.
And I believe we added number 33, or is there another one? Just 33 is left?
Yeah, and just, just for the record, all of these motions in limine are based on the record as we currently know it. Things in trial happen differently. And so if you think a door has been opened or otherwise there are other circumstances which change, we can always do a sidebar to revisit if the circumstances call for it.
Understood.
Okay, Mr. Nelson.
Your Honor, then the last motion we have agreed to deal with today is number 3, which is the spark
their childhood, their education, their career, photographs of the family, family members, and discussion of their occupation. All of that comes from Evans. I think really Morrow is one of the cases that does a nice job of describing some of the case law. But it really gets to this term spark of life, which I always thought came out of Graham decades ago, that the person that we oftentimes just gets referred to as victim is actually a human being imbued with a spark of life, that this puts some personal nature back into the case for somebody who's treated so impersonally, unfortunately, by the system. And so courts have allowed this when it's for that purpose, not unduly inflammatory or prejudicial. And so we fully intend to do that with respect to Mr. Floyd. We will have photographs of Mr. Floyd at various stages of his life. We will have, Your Honor, I think 2 witnesses that would qualify as spark of life, because one is a family member who would talk about Mr. Floyd's family and his growing up and being a brother to this witness. And, as many people know, during the incident, Mr. Floyd references his mother. And so there will be discussions about that, why that was so important to him. Another spark of life witness will talk about more contemporaneous things in Mr. Floyd's life since he came to Minnesota. And quite frankly, we'll also cover some factual elements based on we foresee as attempts to sort of denigrate Mr. Floyd's character. This person will also be addressing some of Mr. Floyd's life, and so it really will be somewhat factual outside of spark of life.
When you say you anticipate that there will be evidence to denigrate Mr. Floyd's life, why I think I've been pretty clear. I'm not allowing that.
Maybe denigrate was too strong of a word, Your Honor. I apologize. Obviously his drug use is going to be an issue in this case. The defense, is going to portray that as a cause, and that becomes part of the medical case then. So there will be discussion about that. There will be some evidence about that. And so that's why I want to be clear that, one of the spark of life witnesses is certainly going to talk about more things than just what's typical and covered in spark of life, but she will do that as well. So just to preview that for the court, that's what we anticipate doing. We will not, let me say this way, we understand what opening the door means, and we will not run afoul of that, though there is some chance that we may ask the court to give us some guidance on that specifically when it comes to that testimony and at that point in the trial, just to be clear with everybody about that.
Yeah, I think we are all familiar. And Mr. Nelson, I'm going to ask you follow-up questions in just a second. We're all familiar with, I think, the spark of life doctrine, that essentially, like you say, that this is not just a person who we label victim, and we depersonalize the person, that Mr. Floyd in this case is entitled to have the jury realize he was a human being, he was loved, he had a family. I agree with all that. I think if it's basically evidence that will not call for cross-examination, I think that's generally well within the bounds. I guess, and I don't have a problem with 2, as long as we're not spending too much time. There's also the case law that says it should not go on and become character evidence. I'm not allowing a lot of the past that would amount to character evidence. And I'm specifically concerned here about, and it may be true, I'm not saying this, but that Mr. Floyd was described as a gentle giant. As soon as you start getting into propensity for violence or propensity for peacefulness, I think then we're getting into character evidence. And then that does open the door for the defense to cross-examine about his character for peacefulness. Everything else, how he grew up, some pictures, that he was loved, that he was a wonderful father, brother, nephew, all that stuff I think is permissible. obviously if we don't go on too long, because it distracts from the merits and what happened. But that's my concern on the line, is that as soon as we start getting into character evidence, number one, I don't think 404A permissible, because it's not, I don't think you don't get a chance to offer peacefulness to the victim until the defense claims that Mr. Floyd's case was an aggressor at the beginning. And we have videotape to show what actually happened as far as aggression or not. Does this make sense, Mr. Frank?
Does, Your Honor, and what I guess what I was trying to get at earlier is, to me, it's not opening the door if a witness says he was loved by everybody.
Oh, of course not.
He was fun to be around. He enjoyed life. We did things together. We went out. We had fun. That doesn't open the door to the kinds of things that the court has ruled inadmissible otherwise.
Absolutely.
So it was there. I was saying, let's have that conversation if we think
Right.
there's a problem before we're calling that witness and putting them on the stand, because they will talk about that, and they will talk about him being loved and being part of a family. And sure, he had some problems he was dealing with in his life. We will talk about that, and that will lead into these other factual issues about the issues in the case.
Well, and I think if, for
Like
example, you mentioned the use of drugs, and if there's any discussion of his struggle with drugs, that's certainly, I think, permissible spark of life. It does not open the door to a lot of the things that we've been talking about. My concern is, because really, if that he struggles, I don't see that the defense has the ability to cross-examine further about that. I can't think of it, at least. I'll put it this way. If you think that opens the door, you better have a sidebar about that, because I don't see it as discussion of use of drugs does not open the door to further past acts, in my view. For example, it does not open the door to the May 16th, 2019 case. But my concern was more descriptions of his character for peacefulness, because that, I think, would open the door to the May 16th case and other priors that we're aware of, because it's proper cross-examination. You say X, what about Y? So that was my big concern about the spark of life. I think everything you've described is perfectly permissible in spark of life testimony. Mr. Nelson, I just kind of your thoughts there. Yeah, why don't you go to the lectern? It's a little easier.
Yeah, I agree. And that's the question, is because a lot of what we've seen in the media and descriptions would, I think, open the door to impermissible, what you have ruled is impermissible character evidence, but it would certainly open the door. The issues, that were ultimately surrounding his drug use and his drug abuse history do play a very central role in ultimately the cause of death. Did he have a tolerance for a particular drug? Would that tolerance somehow make levels that were in his system more survivable to him? Does that make sense? Trying to be as opaque as I can at this point.
Well, let's put it this way. If the medical examiner says that such history of drug use could affect their opinion as to whether drugs were a cause of death, I think it's permissible. My guess is they're going to say whether or not he was a drug addict with a long history of drug use, or he was, this was the first time he ever used drugs, it wouldn't have made a difference on their opinion. Then I don't think you get into the long history, because it's not proper examination. If the doctor says, doesn't matter, that's not relevant to my medical opinion, I don't think it's relevant for us to get into it. But again, I'm kind of predicting, I don't know what the doctor's going to say. And
right. I don't think we'll be in a situation where anyone's saying it's not a relevant concern on either side.
Let's deal with the bounds of the drug addiction evidence when it comes up.
Okay.
And this actually is why you'll notice on the trial schedule, I have the jury showing up by 9:15 to start at 9:30, but every day we are in session at 9 o'clock to talk about legal issues. This is kind of what I've reserved it for, is fleshing out the motions in limine in real time.
I believe then with that, that actually would dispatch with another one of the motions, the defense motions and limit it.
Which one is that?
I'd have to look.
Oh, why don't you
and-
go ahead and look? If we can get rid of another one, that's fine.
Number 35, Your Honor.
I think that covers it. State agree?
It's reserved basically until we get to that
Right.
point. Right.
Your Honor, this is one I think we need to sort of work through a little more, because what we're alluding to, trying to be, I think, opaque, as Mr. Nelson mentioned, is tolerance to some controlled substances is an issue experts will talk about in this case.
Right.
So the finer points of motion 35 really need to be talked through. And quite frankly, I thought we would probably be able to arrive at some stipulations about what comes in through this,
Okay.
what is underlying number 35.
I think what it comes down to is if an expert says that tolerance is an issue or is relevant to a diagnosis or their opinion, it's some aspect of it will come in then. But unless and until somebody says it's relevant to their diagnosis, their opinion. For example, if the state's witnesses say it doesn't matter, it's not coming in. If the defense expert says it does matter, then I think you have a right to present what the actual state of affairs was.
Yeah, and I'm happy to work with Mr. Frank to try to resolve it through some stipulations. And I think that, again, I think the court is wise in its decision to reserve.
Yeah,
until
I
we
think we're
get to
going to
that point.
reserve it then, but you kind of know where I'm thinking the line might be. Again, that's why we're going to be 9 o'clock, not 8 o'clock after jury selection. So I appreciate your working full days here right now. All right, anything?
I think that was it for today, right? We had agreed
Mr.
on
Frank, anything else we have?
That's it for today, Your Honor, that we had.
Okay. We're going to take a 10-minute break. Let's come back at 5:02. And we'll start, I think we have juror number 20, who is our next juror. And we'll start with that at 5 to 9. All right, we're in recess. Thank you. think they're just finishing up the orientation video for the new jurors, so. All right, let's go off the record then. Yeah, let's finish it. All right, Mr. Schaefer, would you get juror number 20 for us? All right. Come on up, have a seat. And you are juror number 20, is that correct?
Correct.
All right. Before I turn things over to the lawyers, I want to go over a few things. First of which is I have to swear you in so that all your answers are under oath. So if you could raise your right hand. Do you swear or affirm under penalty of perjury that you will truthfully answer all questions about your qualifications to serve as a juror?
I will.
All right, thank you. You filled out a questionnaire, and thank you for doing that and taking the time and submitting it. First of all, was everything true on that questionnaire?
Yes.
All right. Is there any change or additions you want to make? Or even change, and when I say change, because sometimes you'll fill it out and then you realize after you've submitted it, I forgot about this or that. And so, I really would like to change something. Anything?
No.
All right. When the lawyers are asking questions, it might inspire something and you might say, oh yeah, I did forget that. This is not a problem. This is the natural way that things work out. You give it your best shot at the beginning and then things come up.
Yep.
So feel free to volunteer that extra information.
Absolutely.
As it stands right now, though, you don't have any.
No, not to my knowledge. No.
Okay. And now you're not supposed to read articles, and I think that was in the questionnaire, avoid media coverage of this. You've been able to do that?
Yes, for the most part.
Okay. And I'm glad you say for the most part, because no matter how hard people try, some inadvertently exposed to something, a headline, somebody says, oh, did you read this? And they tell you about it. And since you're not supposed to tell anybody you're a potential juror, it's not like you can go, right?
Correct.
Any of that happened that you received more information about this case from media or anybody else?
No. And the reason why I said that was just, where this trial is going.
Right.
That's it.
Okay.
Nothing.
So maybe that the timing but nothing about the substance of the case or the parties
and not too much into detail.
No. Okay. Excellent. You did have some knowledge about the case before you were summoned, as most people, all people have. Understand that if you are on the jury in this case, that you must make your decision based on only what you hear and see in the courtroom, what is actually in it. Do you think you could do that?
Yes.
Essentially put aside the things you've heard and put aside also any opinions, because it's okay to have an opinion based on the media. It's not okay to bring in and make a judgment based on your opinion that is based on evidence in the courtroom. You understand that?
Yes.
Right. Okay. You were given a long list of witnesses. Did you recognize any of the names on that list?
Yes, there's one.
Okay. Who's that?
A member of the BCA I'm friends with, casual friends with. That was on the front page here. I started here.
Do you remember the name?
Yes, it is Mackenzie Anderson.
Okay. And how do you know?
We're friends of friends since college, so 15 years, but very casual. Actually, after I saw that list, I went back in my phone. When was the last time I contacted her? We had contact. It was over a year and a half ago, 2 years. So obviously no discussion about the case, and I've not spoken with her in a year or two.
Okay. And have you talked to her about her work, what she does on a day-to-day basis?
Yes, but never before this case.
Okay.
If that makes sense, you know what I mean?
And what does she do? What's
I
your
believe she's a
understanding?
forensic scientist,
Okay.
general term.
Do you think that relationship, or maybe general knowledge that she's imparted to you in your just, casual discussions, do you think that would affect your ability to be fair and impartial in this case?
I don't believe it'll affect that, no. And I was thinking about it, and especially in her line of work, forensics, it's very science. It's not very something where you have to try to get someone to believe something, right? So I don't believe it would affect that, no.
All right. Thank you. There is one item on your questionnaire I did want to talk to you about, and that's the length of trial. And if you are selected for this jury, we will start with opening statements and evidence March 29th. We anticipate it's going to be about 4 weeks, so pretty much into April. And I notice you say that you're potentially getting married in April. Tell me about that.
I believe at the time, I'm still getting married. I believe at the time of the questionnaire, we did not have a date. We have selected a date of May 1st. So that does give me a little bit of cold feet about this situation of, geez, if this goes 4 weeks, it's going to bump right up against that.
Well, and we never know how long
Correct.
jurors will be in deliberation. And so do you think that if you were in deliberation, is there a lot of preparation made for this?
So it is a wedding located in Florida. It's a smaller wedding, but there would be 30 family members going. Flights have been booked. It's not a huge financial undertaking where we're spending tens of thousands of dollars on something that would go away, but it would be an inconvenience, and obviously not the way you want to spend your wedding date, right?
Right. And the question comes up, I hope we are done by May 1st, but with deliberations, as I said, do you think that would be like, you'd be going, we got to make a decision here because I got a wedding to get to, my own?
I don't believe so. I mean, I think if I am part of this jury, I think we would have to make accommodations for that date. I would probably operate under the fact that if I'm on this jury, I will not be able to get married on that date.
Okay.
Like, that's me answering, not my fiance.
I'm going to go out on a limb and suggest that she does not want to be as accommodating, but I appreciate your
Probably, but we understand the process and what needs to happen.
All right, I'm going to pass it to the lawyers then, and they'll ask some questions. So, juror 20, if you would, Mr. Nelson.
Good morning, sir.
Good morning.
Just to refresh your recollection, my name is Derek Nelson. I'm the attorney for Mr. Chauvin. Thank you for your patience yesterday and for coming in this morning.
Yes.
So what I'm going to do, sir, is just ask you some kind of general questions, get to know you a little bit, and then I'm going to ask you some follow-up questions about some answers on your questionnaire. Is that okay with you?
Yep.
I know it's been a while since you've
Yeah.
read this, so if there's anything that you have a question about, we'll talk about it. Okay.
Great. Thank you.
All right. So let me ask you this: if you and I were to meet in some social situation, what would a couple of things you want me to walk away knowing about you?
About myself, I'm a father. I'm a devoted father, into sports, music. I'm guessing if we ran into each other at a social situation, it would be with a beer at a bar, maybe before or after a game or a concert.
Sounds good. And when you first received your jury duty notice or your summons for jury duty, what was your initial reaction when you saw that?
Just a standard reaction. I don't think anyone ever gets a jury duty notice and goes, hooray, I got jury duty. But I've never been involved in this process before. So just standard, run of the mill. Okay, my number was up and now I have to participate in jury duty.
Okay. And how about when you learned that it was potentially as a juror in this case?
Yeah, that changed a little bit where I obviously know the gravity about this case. And when I first read that first line about the case, I kind of took a step back and went, whoa, this is a big deal.
Okay. What were your thoughts? Did you have concerns? Were you?
No, concerns wouldn't be the right answer. I mean, just again, the the magnitude of this case, I would think, is what struck me. You know, it wasn't a, oh no, I can't believe I'm going to be participating in this case, or yes, I get to participate in this case. I think it's just the magnitude of the case struck me.
Sure. How about when you got to the government center yesterday and saw its current condition?
Yeah, I think it just further solidified the magnitude, you know, and reading that juror letter, and then seeing it in person, like, okay, this is, you know, the magnitude does match what I had going on in my head. It's playing out in real life.
Do you have concerns for your physical safety?
Not really, no. And I know that's not a yes or no answer, but obviously, again, back to the magnitude of this case, I know there's a lot of people watching, will be watching, but I don't lie awake at night going, I'm in fear of my safety on this case.
Great. Did it comfort you to some degree to learn that you would remain anonymous?
Yes.
At this point,
Yep.
at least. Okay, great. So I understand based on your questionnaire that you, again, don't say the name of your company. We're trying to protect people's identities here at this point. But I understand you're in like sales management. Is that correct?
Correct. Yes.
How many people work for you?
I work with a team. That's a tough question. I probably work with a team of about 20 people across the U.S.
Okay. Do you meet with them regularly, talk to them regularly?
Yes.
In your professional life, can you think of a circumstance where, and I'm just going to back up for a second. Are you in like a management role of that?
No, not necessarily. More of managing the data, providing information to our sales team across the country.
So, can you think of a situation in your professional life or your personal life where you've been called upon to resolve a conflict between two people?
Yes, I'm sure. Again, probably to very less magnitude for what we're here in this room, but yes.
Right. So I guess the question is what are the tools that you use to try to resolve conflict between
Yeah,
people?
I would say, you know, definitely a very logical person, hear both sides, try to go with what is the best direction going forward, eliminate emotion as much as possible is what I would use in my professional life.
Okay. Now, in kind of in a similar vein, have you been called upon in a conflict resolution to kind of determine which person is telling the truth? Two people come to you. The first person says, this is what happens. The second person says, no, that's not what happened. This is what happened. Right?
Outside of a 5-year-old fighting with his cousin, not really. Again, other than what the general public would come up with, but nothing jumps out to my mind of a complete resolution of trying to find a truth teller.
So keeping it at that simplest, most basic form, a 5-year-old, right? How do you determine, is my son telling the truth or is his cousin telling the truth?
Yep, correct. So hearing the argument, you know, hearing them talk through what happened and assess the situation, maybe, you know, step by step, and, you know, determine who you would go with of who is telling the truth.
Okay. Can you think of a situation in your life where you were 100% certain about something only to later learn that you were wrong?
Oh, I'm sure. I can't think of a specific experience, but I'm sure there's probably at some point in my life where I was in conviction of something and it was not true.
Okay. Are you the type of person who's willing to keep an open mind?
Yes.
So one of the things you'll ultimately be instructed in is that you have to follow the law, even if you disagree with the law. Do you think you can do that?
Yes.
Right. Now, I understand your fiance is a lawyer or graduated from law school.
Correct.
Again, not without saying anything, is she practicing law?
No.
Okay. Does she have an intent to practice law?
I don't believe so.
Okay. But obviously she has an education as an attorney. She has a Juris Doctor, right?
Yep.
And if you were to be a juror in this trial and you were to go home and you heard some piece of evidence or you heard some ruling of law, would you turn to her and say, you know, the judge said this today. Can you explain what this means to me?
I would not. You know, I respect the system and what is expected of me as a juror. And just knowing to handle the case within, these four walls is what's expected of me. So I'm sorry, I'm not sure how you phrase your question, but I do not find a problem with that.
Okay. So you would agree that you could follow the law even if you disagreed with the law,
Correct.
and you wouldn't try to glean any sort of insider information on rulings that the judge may make from your fiance. Is that fair to say?
Yes.
Any concerns regarding COVID?
No, I mean, other than and when going back to maybe the timing of the case, and again, when scheduling a wedding during a COVID era, we are under the impression that you can never schedule anything more than 48 hours out. So in terms of COVID concerns, it would be if there was a COVID incident and the affecting the case timing, if it would have to be delayed or paused for a week. I don't even know if that's possible or what would happen, but for concerns, that would be the only ones.
Now I'm going to just turn to your questionnaire
Yes.
again. I understand it's been a while since you've reviewed it. You've obviously, you're familiar, like all of us, with this case.
Correct. Yes.
And you had, I believe, answered that you viewed a particular video, the Facebook video or the viral video,
Sure.
2 to 3 times.
Yeah, that sounds about right. I would say maybe once in its entirety. And when I say entirety, correct me if I'm wrong, I think it was about 6 or 8 minutes. I don't think it was from start to finish, but I probably made it to the completion of the video one time, and I've probably seen clips of that 2 more times.
Okay. And then obviously maybe little snippets in the media and things of that nature.
Yeah, but outside of maybe a screenshot on a headline, that's about it.
Okay. And have you, it's fair to say you formed some opinions about the case.
Yes, a bit. Again, watching a video, obviously you have an opinion when you watch it, and I tried to share that as best I could in the questionnaire.
Yep. And I guess what I'm questioning is that you understand that that's just one piece of potential evidence in this case.
Yes, absolutely.
And you may see multiple other camera angles. You may see multiple other pieces of evidence. I mean, I think you've seen the witness list, right? It's almost
Correct.
400 people
Yeah.
long. Are you willing to kind of hear both sides, pay attention to all of that, and keep an open mind about all of the evidence, not just that one video?
Yes.
Because you did indicate in your questionnaire that you had a somewhat negative opinion of what you saw in that initial video.
Yep, absolutely.
And you provided a written description, and you say, you wrote that before, during, and after being placed into custody, Mr. Floyd appeared to be under the influence and somewhat unruly. Did you see other videos in connection with this case that may have made it to the media?
No.
How did you form the opinion in your mind that he appeared to be under the influence and unruly?
I am having a little trouble with that statement. I think I've just heard through the case that I'm assuming when someone's in handcuffs, they're in handcuffs for a reason. But no, I did not witness or see unruly behavior, so to speak, during those videos.
So, I mean, you have received information from other sources, friends, family members, colleagues. I mean, people are talking about it, right?
Well, I think yes and no, but that information for me is the both sides to every argument angle, right? Is obviously you see a person who dies in police custody. That is a very negative connotation. And to me, sometimes I wonder, well, who would be on the positive side of that, right? And the term that would have been used was there was a reason he was placed in custody.
Okay.
And that would be where that sentiment would be placed from.
Fair enough. And I think that you answered, there was a question that says, have you talked about George Floyd's death with your family, friends, coworkers, discussed it online? You indicated that you had, and that you've shared the feeling that you have felt the event did not need to end in his death.
Correct.
ultimately you would agree that you would be able to, would you agree that you would be able to put all of your personal opinions, what you've heard, kind of off to the side and decide the case on the evidence that's presented in this court?
Yes.
There is a question about whether you have ever personally seen the police use more force than was needed, and you answered yes, watching the television show Cops.
Correct. So, and the reason I say that is I've never witnessed it in person, but I have witnessed that television show many, many times. In fact, my dad and I used to watch it all the time, and you do see physical force being used within that show.
Okay. And whether it was more force than was necessary, I guess perhaps is a question.
Sorry, what was the end of that question?
The question was whether it was more force than was needed.
Correct. And this is coming from a viewer at home, not having all the data. Right?
Sure. Okay. I want to ask you briefly about your relationship with Miss Anderson.
Okay.
How did you get to know Miss Anderson?
So one of my best friends in college was friends with her in high school. So kind of a friend of friend that started probably in college. We remained friends for a couple of years. She went to grad school and weren't really in a close talking relationship. A few years ago, we played a rec league volleyball team together, I believe for 2 summers, 1 or 2 summers. But again, haven't spoken to her in probably a year and a half, and obviously nothing about this case.
Perfect. So I guess my question, because you had said something when the judge was asking you about it, about, you know what she does for a living, and that her role probably would be somewhat minimal, and not minimal necessarily, but somewhat, I'm trying to remember the phrase that you used, but that she wouldn't be attacked, her credibility would not necessarily be attacked.
Correct. I think I phrased in the form of her position in the BCA is, revolved around science and fact. So when you're talking about someone testifying, it's not really a witness that, do I believe this person or not? It's usually something that someone with this background, professional background, will be sharing something that's hopefully supported by science, right?
Okay, so let me ask you this hypothetical question. If talking